Expected today in the shooting death of an unarmed teenager in Michigan. Theodore A says he feared for his life when he heard banging on his door in the early morning hours. He shot 19-year-old Renisha McBride on his porch, killing her. His lawyer says Wafer acted in self-defense. The prosecutor says the victim came to his home in search of help after a car accident and was murdered.
When you take a weapon that could have been loaded and you point it in an area where you know there was a person, or that a person had, or a place where anybody could be, and the gun goes off and someone gets hit, that's murder in the second degree.
One, then you have to decide amongst yourselves. Was Ted in fear of his life or great bodily harm that night? And two, is that danger imminent?
Our legal panel joins us now. Doug Burns, criminal defense attorney, and Keith Sullivan, prosecutor. Thank you both for being with us. Under Michigan law, there is no duty to retreat, but you're only allowed to harm someone if you have a reasonable belief that you are in imminent danger and deadly force is the only way to protect yourself. Doug, does Theodore Wafer meet that burden here?
I don't think he does. I think jurors are smart and they look at objective facts such as A, it's a 5'4" unarmed female, things of that nature. And the other point I would make real quick before I want to hear Keith's take is that it's not so much that he's in fear for his life as some kind of generic across the board. It's at the moment of the encounter. And I don't think you really have that, Keith.
So, I mean, she's banging on the door at 4:30 in the morning. He hears this banging. He wakes up. He's nervous, doesn't know what's happening, but he opens the door, shoots her through the screen door.
Yeah, it's certainly a bizarre and odd set of circumstances, and people are strange and they act in weird ways. And it's not how would we act in those circumstances, whether or not his behavior was appropriate or not, according to our views, but it's what was his subjective analysis at the moment, as Doug said. The moment he pulls that trigger, what's going through his mind? From looking at it from the defense perspective, and we get to analyze this in a very sterile atmosphere here, right, well after the fact, he has a split-second decision to think. He's woken up at 4:30 in the morning, he's in a sound sleep. There's ferocious banging at the door. A drunk individual is out there. He opens the door up, and somebody comes running across the porch, and he shoots. He's entitled to do so in his own property, on his own house. You know, the question is, was it legitimate? Was it fearful? And what I have a concern for is, when the police arrived, he said it was accidental. And self-defense is not accidental.
Right, he did change his story a little bit.
That's the problem.
I know that we have more to say on this, but we have to move on to our second topic, Oscar Pistorius. That case coming to a close. Closing arguments today. Then the judge is going to adjourn for a couple of weeks and then make a decision. Pistorius says he thought his girlfriend, Reva Steenkamp, was an intruder. He shot her 4 times from the other side of the bathroom door. Prosecutors say he killed her after an argument. Keith, what do you say?
This whole trial has been quite a bit of a circus act. So many different crazy things going on. But what we got to see was something very interesting, which you don't always see in trials, which is the defendant actually testifying. And he was subject to some pretty scathing cross-examination. They can charge him with murder, which is an intentional crime. I don't think you have it here. You don't have any journal, you don't have any text message, you don't have any words to someone else saying, I'm going to kill her. He gets the gun, and in order to get her a murder, you have to know that at the time he picked up the gun, he intended on killing her. You're never going to be able to get that here. You could have murder, which is when he makes the decision at the time, or culpable homicide, which is very likely. But keep in mind, he's a celebrity. How is this judge going to look at that?
He's a celebrity.
You know?
We know him as the Blade Runner. He's an Olympic athlete, runs on prosthetic legs, considered a role model for a while, but defense says he's vulnerable and scared inside.
But there's really bad news for that theory, which is there's no jury, okay?
Yes.
If this were a jury trial, my God, his celebrity status, what everybody thinks of his athletic heroics, you know, while it shouldn't necessarily form your verdict, it's a big part of it. So here it's being tried to a judge and 2 assessors, and, you know, it's interesting because he's charged with 3 gun offenses also, so I don't see any way around him getting convicted on that. But I agree with Keith. I think the idea of a premeditated killing might be a little difficult.
Yeah, interesting. All right, Doug Burns, Keith Sullivan, thank you both for joining us.
My pleasure.
Wait all that. In the meantime, we also